And welcome back to For Couples. Now, this week we are here with Miss Kendra Clark, and she is with the DeVetter Law Firm, correct? And Miss Kendra is going to be telling us how to get our finances in order with regards to wills and trusts, because we have to protect our loved ones. So I'm just going to turn it over to you. So I'll give you a scenario.
Okay.
Married. Or living well, let's start with married, because I know married and living together is totally different things. Mm-hmm. But married, what do married couples need to do when they get married so that their affairs are in order in the event of an untimely death?
So the biggest thing is, I'm actually our probate paralegal. So we're dealing with things where we have to actually go through the probate court to have a personal representative name for the estate.
Okay.
And even if you have a will, you still might have to go through the probate court.
Oh, okay.
But there are things you could do to avoid that, because obviously if you can just handle things on your own without having to file paperwork and wait on the court and get a judge to rule and then possibly have to file reports, all the better.
Let's do
that. Okay. So the first thing is obviously, drafting a will and or a trust. So the best example I've ever heard of the difference between the two. So a will is just saying, these are all the things I want to happen with my assets, with my affairs. But once you pass, someone has to go and figure out what all those assets are and put them into a bucket before they can disperse them. Okay. All right. Where a trust is basically like an account where before you even pass, you put everything into the bucket. So once you pass, whoever's in charge of that, they just take the bucket and they already have everything there.
Gotcha. Okay.
And so a couple ways you can avoid probate court with a will is, one, if you have a trust and you actually fund the trust. The biggest mistake people make is they get all the documentation to create a trust and maybe put their house into it, but then they never transfer their accounts into it or all the other. So if those things are outside of the trust, then you may still have to go through the probate court.
Okay, so that means like my checking accounts, savings accounts,
stocks, bonds, anything you possibly have. Because I know we actually have a client we're working with right now. They had a trust and they've been able to handle everything except for one account, because that one account wasn't put into the trust. Okay. And now in order to get access to those funds, they have to go through the probate court. Oh, goodness. So, so a trust and will are only as good as the steps you do to prepare everything beforehand.
All right. So if we're married but only one spouse's name is on the house for whatever the reason.
Yes.
And that spouse passes away, what does the wife or husband need to do to protect them from losing their house?
So if the one spouse's name was only on the house, then at that point it would have to go through the probate court. Okay. And the way it works with who's determined the heirs is it would be the spouse and then any children that person had. So that's when it can kind of get complicated depending on what your family dynamics are. Because we always like to say, death brings out the best and worst in everybody. Yes. And so unfortunately we see both sides.
Oh, yes.
But, at that point, you would have to either get the children, if they're willing, to just sign it over to you and give it all to you, but they're not always willing to do that.
True.
Then you have to buy them out. There's a lot of different things. But to avoid that, because we want to be preventative.
Right. We're all about preventative measures.
We want to get everything in place so we don't have to do all that.
Okay.
So if you are married and your spouse's name is the only name on the house, then you want to get your name added to the deed. But not only added to the deed, it specifically needs to say that you have survivorship rights.
Are you guys listening? Survivorship rights. Okay.
Yes. Because even if both your names are just on there, then that's basically like you have an interest and you have an interest. The husband has an interest. The wife has an interest.
Okay.
So if you don't have survivorship right, husband passes, well, what happens with his interest? It doesn't immediately go to her.
Okay.
And so that's where, but if you have that survivorship rights in there, then wife gets all the rights to it. So.
All right. So for those of you who are paying attention, may have just purchased a home or may have been in your home 20 years. survivorship rights are necessary. So
Yes.
add your name to the deed, and that can be done at the courthouse, or
So I mean, you could probably do it yourself, or you could hire an attorney to draft the paperwork for you. But then it does have to be filed with the Superior Court clerk.
Okay.
To kind of like put it on the record and make it official.
All right, so get your name on the deed, then get survivorship rights. Now, is that like a form you go to the lawyer and get?
It's just the wording in the deed.
Oh, okay. Gotcha.
In the deed, it'll say that the house belongs to these people and that they have survivorship rights.
Okay. Now, let's talk about money.
Okay.
Now, we got the house taken care of. So, you have, let's say you've got this couple and he has an account that's just his name. She has an account that's just her name, and they have account together, which a lot of couples do.
Yeah.
So what does the spouse need to do, say if the wife passes away and his name is not on the account and there's $100,000 in there that we just don't want sit there?
Yes. Because you want access to that money, obviously.
Right.
But the best thing to do is to make sure that you have a beneficiary name for any accounts.
Oh, okay.
So whether that is, so that doesn't mean they have access to their account, but that means that if you die, they're the person who receives it. And you can even designate, so say you want your spouse to get 50% of it, but then you want your child to get the other 50%, or you can have the beneficiaries designed however you want and have percentages assigned. So, but by having those beneficiaries designed, then once you pass, all you have to do is fill out the beneficiary form and you get that money.
Awesome.
And you also want to have you want to have a secondary beneficiary. So say you have your spouse listed as your beneficiary, but then maybe your spouse dies before you. If you don't have a secondary listed, go to probate court after. We want to avoid probate court.
We're trying to avoid probate court. We love you, judges, but we're trying to avoid probate court. Awesome. Okay, so how do you file a will? So let's say, because a lot of people go to, I think it's Legal Docs or Legal Zoom or something like that. But a lot of people go to the internet for their legal documents. So let's say I draft my own will. How do I then get that filed so it can be, my loved ones don't have any issues?
So you can file a will with the probate court. Or, I mean, you don't have to file it. So if you have like a safe place and everybody knows where it is, but it's important to know that the probate court does need original wills. So copies, I mean, if they absolutely have to, there's things you can do, but you need to be original. But the biggest thing we run into with a lot of online services is you've got to make sure that the will meets the criteria for Georgia law.
Okay.
So like the biggest thing is you want to make sure you have at least 2 witnesses.
Okay.
And those witnesses cannot be the beneficiaries of the will. So if you're receiving anything in the will, you cannot be a witness. Because that like basically X's you out. Like you don't get anything anymore. So because you want it to be 2 people who are unbiased, who don't have any skin in the game. So you want to have a beneficiaries, but also if you go through like an attorney these days, they'll also do what's called a self-proving affidavit. So what that means is it's just like an extra step to make it extra authentic.
Okay.
And you have the 2 witnesses and also a notary and certain wording. And what that means is that document self-authenticates itself. You don't have to have additional signatures or things after someone passes.
Okay.
Because if it isn't self-authenticating, then if you have to go through the probate court, we have to do what's called interrogatories to the will, which is basically we send questions to the witnesses being like, hey, is this your signature? Did this person who passed, did they actually sign the will? Were they competent? Did they have the capacity to make that decision when they signed it? Did they know what they were signing? And then we have to hunt down people. So I said, we want to plan so the process is as easy as possible, because I mean, you're already dealing with the loss in your family. You don't want to have to deal with all this extra drama as well.
And we so often hear about celebrities in particular, where they can't find a will. They didn't have a will. The will was in the cushions of the couch. And it's like, what? I don't understand. Why would you even do that to your loved ones? Especially people with, large amounts of money. And, you know, like you said, death typically brings out the worst in some people sometimes, and you have cousins twice removed showing up who you've never seen before. It just can cause a lot of grief.
Absolutely.
So, with regards to that, what about video wills? Are video wills legal?
Not that I'm aware of.
Okay.
So I can't speak with full authority on that, but I don't think so.
Okay, so I can't just leave a video saying I want my cousin to have all my wigs.
No. I mean, some people might not fight you on it, but no, I don't think the court like honors that. So.
Oh, okay, I was just checking. Okay.
It also can't be like a notepad where you just write everything and sign it and like nobody watches you. Like there has to be certain legal wording. So,
Gotcha.
we do see that sometimes.
Okay.
You know, somebody's got like a napkin. It's like I give everything to so and so.
Right. Okay. Now, for people who may have minor children, or maybe children that may be adult children, but they're special needs children, and they want to ensure that these children are being taken care of upon their death, either or sometimes a simultaneous thing of both parents. What can parents set up so that their minor children and or special needs children or special needs adult children are taken care of?
So specifically for special needs, there is actually what's called a special needs trust. So it's specifically designated for people that have maybe some sort of capacity issues or have different needs. And that way you could specify not only like assets and like what money they get, but also how it gets divvied up, but also who's responsible for helping them make those decisions if they can't make those decisions themselves. And if you can set up a lot of that stuff ahead of time, because the other thing that it does with the probate court is they also do guardianships and conservatorships. So guardianships is dealing with helping make decisions for the person, so medical decisions, where they live. And then conservatorship is making decisions and having oversight for their money, which obviously became a big deal in the news when like Britney Spears and like all that.
Oh, that was huge, yes.
You know, that got people's attention, like, what is this thing?
And why is somebody controlling my money?
Yeah. But there are things that you can do, not all the time. Sometimes you still got to go through probate court to get certain things, but you know, there are other things you can do to prevent that as well. So having, if they have enough capacity to name a power of attorney, or a healthcare directive. Now they might not have that capacity. They might not have the ability to be able to sign off on those things. But, you know, if they have that, it's always easier to do that up front.
Gotcha. Okay. Because, I mean, unfortunately, you may leave some minor children behind. So, okay. So now, I also want to ask, and some of our viewers may want to know about, okay, so we're not married.
Yeah.
Oh, but we've been living together for 15 years. I know I have rights. Do I really have rights?
No, you don't have any rights. But that doesn't mean that you still can't take care of someone. So once again, you can still add them to the deed. You don't have to be married to be on a deed with someone. You can still name that person as a beneficiary. Okay. You can still have, if you have a joint account, then you automatically get that money. Right. There's no fighting over that. That doesn't mean that children might not come along and be like, actually, we want all that money.
Okay.
But it's pretty hard to fight a beneficiary. Like if you say on your bank account, I want this person to receive my money if I pass, the bank's going to honor that, 99% of the time. Okay. So unless just something weird comes up.
All right. So would it be for our couples who may not be, married, but are living together and have been living together for really a long time, would it be wise for them to just go ahead and put a will in place?
Absolutely. Okay. Especially if they want that person to be the person who receives their assets and their accounts and all those things. Because also that just solidifies that that's what you want. That's what your wishes are. And it makes it a lot harder for anybody trying to fight anything.
Gotcha. Okay. Now, also, my mother passed several years ago, and she had a checking account, and she didn't list anyone as a beneficiary. Yes. So my sister and I had a really hard time trying to close the account. They wouldn't even let us close the account. So what are your suggestions for maybe children, survivor children who they weren't listed or their parents didn't even know they could list the beneficiary on a checking account. What do you suggest for children's survivors who need to handle the affairs of their parents?
So at that point, you have to go through the probate court. Now, if it's I'm trying to remember what the amount is. So there is a form if it's less than a certain amount. Mm-hmm. There's literally just an affidavit you can sign and take to the bank. But if it's over that amount, and I can't remember what it is offhand, but you go on the probate court's website, on the form it says small bank accounts under X amount.
Oh, okay.
But if it's over that amount, or if there's any like houses or stocks, then you have to go through the probate court. And so if they didn't have a will, then you have to file what's called a petition for letters of administration. Mm-hmm. If they did have a will, but maybe the property, you don't have those survivorship rights, or it was your parents' house and so you're not on the deed, then it would be a petition to probate will in solemn form more often than not.
Okay. And one last question. Now, I haven't heard this term in a really long time, but I used to hear it like younger, mm-hmm. Especially with a lot of elderly, where it was called heirs property.
Yes.
What is heirs property?
So heirs property is just like, I believe, just like multiple people own the property because they're the heirs, so they inherit it. So when, if you have a family member who dies and there are a lot of heirs, so there are a lot of people that it's going to, or even it doesn't have to be a lot, then that property is divided up between all the different heirs. They all have a percentage interest. Okay. So if there are, say, 10 siblings, they each have a 1/10 interest in the property. And there's a certain kind of deed that's initially done to divide that the 10 ways.
Oh, okay.
It's called an assent to devise, I believe.
Okay. So. And is that where if one sibling doesn't want to sell, then nobody can sell because everybody has to agree? Is it like that?
Kinda. So, I mean, it's always easier. There are things you can do if you want to sell to like force people's hands, but I don't have enough knowledge on that to speak on it. But but more often, if you can get everybody to agree, that's obviously the best. Or if they don't want to sell but you don't want to keep it, they always have the opportunity to buy you out as well. So they can, if they're like, hey, I will sell you my portion, or buy your portion from you, and they can actually just write you a check and then transfer their interest to you.
Okay. All right. And just a couple of takeaways just so we make sure everybody is clear. Mm-hmm. So when you're creating a will or a trust, it's better to just ask an attorney.
Yes. Because you want to make sure it's done right. You want to make sure that all of the wording is correct. Because if it's outside of what Georgia law allows, then it's not deemed valid. Okay. And also, an attorney's going to typically keep copies. So, like, if family members lose it, you can be like, hey, mom passed. Do you have a copy of her will? So you want the original, but if it gets lost, there are things we can do, so at least you have a copy.
Okay. And then a will is a legal document that spells out how you want everything in your assets divided. All right. And a trust is more of an arrangement as to the one person, if he divvies up, or she divvies up everything that's in the basket.
Yes.
Okay. And then one more thing. What is a durable power of attorney, and do we necessarily need one?
Yes. A durable power of attorney is basically giving someone authority to make decisions for you. And you can make it specific to situations. And this is something really everybody should have. Like, even if you don't like own a house or have a lot of money, like, this is so if you get into a car accident and you are in a coma and like you need someone to make decisions for you. If you ever develop dementia or something where you don't have the capacity to make decisions. And power of attorney, you can give people very limited powers, or you can give them power to do anything and everything. So they can sign contracts on your behalf, they can buy property on your behalf, they can, or you just do like, hey, I want this person to have certain powers, but only in this specific instance. Gotcha. So there's a lot of variations in the way you can do depending on how much power you want to give somebody and how much you trust people or the person you're giving that power to. So, but yeah, so it's definitely good. Just, and if you ever get to the point where you can't make decisions for yourself, then you want to have somebody that can make those for you. And once again, you're not having to go through the probate court to get guardianship or conservatorship to make those decisions. And one thing they did recently also was they created a mental health power of attorney.
Okay.
That's a very, very new. They just passed it this past summer. Where if you have yourself or a family member has some sort of mental health issue and you want to give to people power to get you medical help, if you're ever in crisis, then you can sign that. So if you're to the point where you don't really know what's going on, or maybe you're suicidal, things like that, you can have somebody you're like, hey, if I get to this point, I want you to help me, and this paper gives you the authority to do that.
Okay. And for our families who may have minor children, can they leave guardianship as part of the will, or is that something separate?
They can.
Okay.
Well, I mean, you still have to make it permanent through the courts.
Right.
But you definitely want to put in there who you wish. You don't want it to be a fight, or and obviously have a conversation with someone before you have it.
Right.
Don't be like, I want Kendra to be the guardian. Then you pass, and I'm like, wait, what?
We're not in that talk.
No. So definitely have that conversation beforehand. But you definitely want to leave that in your will of who do you want to take care of your kids.
Right.
You know?
And that's crucial, especially people with minor children.
Absolutely.
That is very crucial. You don't want them to fall into the system while the relatives figure out who gets, the child. Awesome. Well, thank you so much, Kendra, for coming and sharing this information, very crucial and vital information with us, because we need to know these things, especially when we are getting married or if we are living with our mates, and these are just things we need to know. So again, this is Miss Kendra Clark. She is the paralegal for DeVetter Law Firm. Please call them if you would like more information or to schedule an appointment to create your will of trust. Join us on our next episode of 4 Couples.